Mr. Lim Biow Chuan.
Mr. Deputy Speaker, I declare my interest as a lawyer where part of my legal practice involves matrimonial law. There are two parts of this bill which I wish to speak on. Clause 81, court orders on maintenance enforcement application. Currently, when an applicant applies to court for enforcement or maintenance, the frustration is always with the possible delays in the receipt of the maintenance. Delays happen when the respondent does not turn up in court. The case is then adjourned. The next time the respondent turns up, he applies for an adjournment to engage a lawyer. The case is then adjourned again. And sometimes the court sends parties for mediation, and the case is adjourned again while parties try to find an amicable solution. If the respondent disputes a claim, the court will direct parties to prepare their case, and more time is taken up. In the meantime, the applicant suffers because of the time required to attend court again and again, and the failure to receive the maintenance which has been ordered to be paid to the applicant. Now, even if the respondent were to eventually make payment of the arrears of maintenance, there's this possibility that he may default in payment again. Then the applicant has to start the process all over again. Thus, there will be times when the applicant may eventually give up on the maintenance application and decide not to enforce the order. This is unfair to an applicant who has been granted the maintenance. Hence, sir, I support the amendments to the Women's Charter to allow the appointment of the maintenance enforcement officers in order to have a more sustainable maintenance outcome. The maintenance enforcement officers would then be empowered to carry out investigations on the assets of the respondent and then report to the judge. Without the information given by the maintenance enforcement officers, the applicant who is trying to enforce the maintenance order will have a difficult time trying to check what are the respondent's assets. In particular, the courts should be given the powers to act expeditiously and to make interim order whenever necessary to ensure that complainants or applicants who are financially stretched are able to receive the maintenance that they deserve and are entitled to receive. Otherwise, the applicant would typically suffer, and situations where there are children involved will result in hardship for the family. Where the maintenance enforcement officers are able to ascertain that the respondent is deliberately refusing to make the maintenance payment, the court should not hesitate to attach the salary of the respondent or attach his other assets in order to enforce the maintenance order. In addition, the court should consider ordering and making an order that the respondent's credit cards be cancelled until the arrears of maintenance are settled. Where a maintenance enforcement officer finds that a respondent's conduct in refusing to pay the maintenance is contumacious, I would submit that the court ought to punish the respondent for wasting the time of the applicant, the time of the maintenance enforcement officer, and wasting the time of the courts. The respondent should not be able to get away with delaying the maintenance payment just to frustrate the applicant, and then he walks away without consequence once he pays up the arrears. So I recognize that there may be occasions where a respondent may be unable to make payment of the maintenance because his family circumstances have changed. For example, if he loses his job, or sometimes if the respondent remarries and has to support another family. In situations like this, I expect that the maintenance enforcement officer would recommend a variation of the maintenance order. May I then ask the Minister, how would the court make a reasonable variation order which can take into account the needs of an applicant who is reliant on the respondent's maintenance for herself and the children versus the financial needs of the respondent who now has to support another wife and possibly his other children? May I also ask whether the maintenance enforcement officer is able to investigate and deal with cases where a respondent resigns from his job and has no more income as he simply wishes to deny maintenance payable to the applicant. The loss of income in this case is or would be self-induced with the intent of denying the applicant the maintenance which she ought to be entitled to. How would the court also deal with situations where a respondent refuses to pay child maintenance because he is denied access or visitation rights to the child. Would the court be able to deal with such situations even though the application before the court is an enforcement of maintenance application? Or would the court require a separate application for enforcement of the access rights? So the next part of the bill which I wish to speak on is the enhancement of judge-led approach in considering the wishes of the child. So in the media release by Ministry of Law, it was stated that the bill will provide clarity that where the wishes of the child are to be considered by the court, the judge may conduct interviews with the child. The current legal position is that the court, in making decisions about a child, may appoint a child representative to the court, or the court can appoint a trained or professional assessor to make recommendations on the child's custody or access orders. The appointed assessor would then prepare a social welfare report, or a custody evaluation report, or an access evaluation report. The judge may also ascertain the wishes of the child by conducting an interview with the child, and there's been case laws on the power of a judge to do so. However, may I express some reservations about a judge carrying out interviews of the child, because a judge is typically an authority in the law. He or she is not a trained child counselor who can discern whether a child has been coached to express certain views or is under duress to say positive things about one parent just by one interview. Although some judges may have some degree of training in handling children, the reality is that a judge spends more time analyzing the law and facts applicable to a case. Thus, unless a judge spends a much longer period of time talking and interviewing the child, I do have some reservations whether a judge is able to make a better assessment of the wishes of a child by a simple interview, as compared to trained social workers who will be spending more time talking and interacting with the child and observing the expressions of the child. So may I ask the Minister to clarify, what is the intent of this amendment, as the current case law does allow the process? Is it the position of the government that they prefer that judges carry out the interviews more regularly as compared to the judge appointing social workers or a child representative to take care of the child's interests? At the end of the day, what is important is how to ascertain what is in the best interest of the child. Subject to the above clarifications, sir, I support the bill.